Los Angeles County, Philip Dube. And Philip, I thought the defense did a fairly good job, and I think it's testimony, the fact that they've been out 11 hours at this point, that of muddying the waters just enough, and I use that euphemistically considering one of the issues is that it was all rainy and terrible out that night, but they brought in all these other factors. And what the state wanted this jury to believe is that none of that really mattered. What mattered were her decisions, right, to drink, to drive, that led to this fatal accident that ended up killing this police officer. What do you think about what the defense did here and the fact that perhaps that's what this jury's struggling with?
Well, there are really two issues for the defense, and that is causation. And for viewers, all that means is anytime you have a death, they have to prove that the defendant on trial was in fact the proximate cause of the death, right? And then they also have to prove intoxication. The misnomer or the misunderstanding across this country is that people seem to believe that it is illegal to drink and drive. It is not illegal to drink and drive. It is only illegal to drive if you are under the influence of alcohol, drugs, or both. By all accounts, apparently this lady can hold her liquor. Yeah, she may have been seen on video, pounding her beer and having her vodka shot. But at the end of the day, there really was no chemical test to prove that she was in fact over the legal limit. Instead, what they had is they had an opinion from a guy who did what we call retrograde extrapolation and basically estimates what she would have been based on what he saw in the video. Based on a timeline, they can determine how much alcohol was absorbed into her bloodstream based on her height, her weight, her overall stature, maybe based on what she ate earlier in the day, and the quantity, of course, of alcohol that she drank. And based on that timeline, they're trying to estimate what her blood alcohol concentration would have been at the time of impact, at the time of driving. And I think the jury may be struggling with that because at the end of the day, there really was no breath, blood, or urine test collected from her. Additionally, you have causation problems. They're saying that because she was going, between 43 and 47 miles per hour in a 35-mile zone, that she was blotto. Therefore, she was impaired. What's interesting is when you look at the driving patterns, the instructions that's given to peace officers, they follow the national standards from NHTSA. It's called the National Highway Traffic Safety Administration. And ironically, one of the driving patterns that's not on that list in detecting DUI drivers is speeding. Speeding means you're alert. If you are weaving in traffic, or if you're driving without your headlights on, or you're driving too slow in traffic, those are classic indicators of someone being under the influence. But going over the speed limit, quite frankly, is with the normal flow of traffic because hardly anyone drives within the speed limit. So I think this jury is struggling with whether or not she was truly impaired and whether or not she was the legal cause of this man's demise.
Yeah, that's interesting because the speed limit on that road was 35. They're claiming that it was between 45 and 55. Of course, they can't pinpoint it, but based on some of that the scene reconstruction where he ended up, that's the accusation that they're making. And I think you make a fantastic point because at the end of the day, when you think about what she did, and they have some pictures, they have some video of her crossing the middle line, but these are all things that we all do. Right? I mean, really, I cross the line sometimes. We all, exactly.
Okay.
Right. We all, the first person should cast a stone because we all do. We all certainly drive above the speed limit. So those two things. So I think what this jury's struggling with here, Philip, might be the levels. So what the judge told them was you start out at that vehicular homicide with intoxication. Maybe they don't feel that she was intoxicated. Then they get to the fact, was she driving recklessly? What was her standard of care? Then beyond that, there's the criminally negligent homicide and very different penalties there, right? So at the end of the day, that could be what this jury might be struggling with.
Right. And by the way, in my opinion, she's dead in the water on the hit and run. hit and run is not a fault-based crime. In other words, the law doesn't really care for criminal purposes who caused the accident. Instead, it's a duty-based crime, meaning if you're involved in an accident, you are duty-bound to pull over immediately and exchange personalia such as your name, your address, your phone number, the name of your insurance carrier. And of course, if somebody is injured, you're duty-bound to render aid, because if you just flee the scene, it's very possible that the person's injuries may be exacerbated, or they could succumb to their injuries. Who knows? I didn't hear all the evidence. Maybe this officer's life could have been saved had she pulled over and gotten on her cell phone right away, or made arrangements with someone, flagged somebody down to get him an ambulance. We don't know. But the bottom line is, had she have pulled over, I don't think she would be in this posture. I don't think they would have filed it as a murder. I think it would have been a vehicular manslaughter, which carries a determinate sentence and not a life top.
Yeah, you know what's interesting about that? I wonder if it was a net positive that she did leave the scene. There's a 1 to 6 for that leaving the scene of the crime and the hit and run, as you're talking about, right? So clearly, I agree with you. She's going to get convicted on that without question. She absolutely did that. But if she stuck around and they found that she was above the legal limit under the same circumstances, remember, this was a police officer. So I don't know if they're going to go easy on the charge here, and she might have found herself convicted of that top charge without having the benefit of this jury trying to decide if she was intoxicated or not.
Well, I take issue with the fact that we have classes of victims in our criminal justice system, that certain victims are more venerable, if you will, for sentencing purposes, that we should go harder on people, for example, who accidentally run over a judge, or somebody who collides into a peace officer, or if there's a DA who's shopping and they accidentally get clipped in a drive-by shooting. But, because of who they are in society, the law goes extra hard on them. And I'm not saying that men in blue do not deserve the respect that they do get. They absolutely do. But I don't think that law enforcement should come down extra hard on a person merely because their victim was a peace officer. This could have happened to anybody. It was just a tragedy, wholly unnecessary and a tragedy.
Yeah, quick on the legislative history there. There was an investigative report done back in 2016 that showed they were being too lenient. Even though they have some of the strictest DUI laws in the country, they were being too lenient in charging and in sentencing. So that may have played a role as well, because now they've ratcheted up in terms of the sentencing and the charging in these types of cases. All right, stand by, Philip Dube. I want to take a quick break right now. When we come back, our talk back question for tonight is